Coming up next on Arizona Horizon, it's our Supreme Court preview show. We'll look at some of the major cases on the docket for the High Court's upcoming session with ASU law professor Paul Bender. A Supreme Court preview next on Arizona Horizon.
Arizona Horizon is made possible by contributions from the Friends of Eight, members of your Arizona PBS station. Thank you.
Good evening and welcome to Arizona Horizon. I'm Ted Simons. The U.S. Supreme Court is set to begin another session. Among the cases the justice will be considering this upcoming month include issues ranging from affirmative action and the death penalty to another Arizona redistricting fight. Here to help us make sense of it all is ASU law professor Paul Bender. Good to see you again.
Good to see you, Ted.
Great to have you here. I love this show. Let's get it started. Every time we talk about the Supreme Court, it's Kennedy Court. Is it still a Kennedy Court?
Yeah, but it may be a different Kennedy Court. Last term might have been a really significant term in terms of the history of the court changing direction. Since about 9 years ago, Justice O'Connor left and Justice Alito replaced her. Since that time, the court has been four very conservative justices, four moderate to liberal justices, and Kennedy, the swing vote. He would agree with the conservatives about 2 or 3 times as often as he agreed with the liberals. So 2 or 3 times as many decisions came out conservative and liberal. Last term, he did exactly the opposite. He agreed with the liberals over and over and over again in important cases that 5 years ago he would not have been on that side. And so the question is that just an aberration for 1 year, or is he really changing into more of a liberal justice? If he does, the court changes into more of a liberal court. It happened to Harry Blackmun earlier in his term. After Harry Blackmun wrote Roe and Wade, that transformed him from a really strong conservative to what ended up being about the most liberal justice on the court.
Interesting.
Because he announced an individual right. People got really mad at him. They were very ugly in the way they were mad. That pushed him away from them, and it got him to think that he had done the right thing. And the same thing has been happening to Kennedy. I mean, here Kennedy is a conservative guy. He did what he thought was right, and he's being reviled as a big mistake. I think that having the experience of creating a new constitutional right, which he did in the gay marriage case, and generally the community feeling he did the right thing, getting good grades on that, might encourage him to take individual feelings, empathy, the disadvantage more seriously, rather than to, as conservatives tend to do, treat the thing as just, let's look at the words, we don't care about the effect on people. So he may be becoming a more people-oriented justice, and if that's true, the court is going to change.
Before we get to the cases now, you mentioned Blackmun and you're talking about Kennedy. How often does a Supreme Court justice change radically throughout the course of a career?
Not very. Almost never. Blackmun's probably the most extreme example. Stevens is a little bit that way. He was appointed by a Republican president, and he started out being sort of in the middle of the court. He ended up being the most liberal justice on the court. But that is really rare. People tend to stay with what they were.
All right, let's get to the cases. We'll start with Arizona, another redistricting case. This one differs from the last one because it's not, the last one kind of said, all right, we now know who has the power to redistrict, correct?
The big difference between this one and the last one is the last one, which the commission won, was about congressional districts.
Right.
And the Republicans in the legislature said that the commission could not draw the congressional districts because the Constitution says they should be drawn by the legislature of the state. And the Supreme Court decided that the legislature of Arizona was the people of Arizona, and which seems to me to be correct. If you read the Constitution, it's clear that the people are the ultimate legislature. This case involves the districting of the state legislature. There's no problem with the federal Constitution. It doesn't say anything about how the state legislature should be districted. That's a question for the state to decide, and the commission therefore does the state districts. What the challenge is here is that when the commission did these districts, we still had an operative Voting Rights Act with Section 5, so that everything the commission did had to be pre-cleared. And it was clear from the beginning of the commission that one of the main tasks was to come up with a map that would get pre-clearance. because if you don't get pre-clearance, you can't apply to get out of from under the Voting Rights Act. If you haven't done anything wrong in 10 years, I think, you can apply to get under coverage. So everybody on the commission wanted to do something that would be pre-cleared the first time. So they tried hard to get districts that complied with the Voting Rights Act. That means they had to not reduce the number of districts in which minorities, mostly Hispanics, were a majority, because you can't redistrict and have the result be to reduce minority voting strength. So they came up with, I think, 9 or 10 minority districts. But in order to do that, they had the other big constitutional rule is that the districts have to be of equal population. Well, you're allowed to deviate from that a little bit, because sometimes it's just impossible to do equal population. I mean, you have to go 10 miles away to get people to put in this district, so you don't do that. Here, they did it in order to comply with the Voting Rights Act. So some districts are smaller, that is, have more people. Other districts have less people. The districts that have the greater number of people are almost always Democratic districts. I mean, Republican districts,
yes.
Sorry. And the districts with the smaller number of people are Democratic districts. And so Republicans are challenging that as being politically biased in favor of the Democrats.
Is that a one person, one vote kind of a thing?
That's where you start. It's one person, one vote. And the question is, can you make variations? Can you make deviations from one person, one vote? And you can make some because of physical things, political boundaries. The question is, can you make deviations in order to favor one political party or another? The commission said it wasn't favoring a political party, it was just trying to comply with the Voting Rights Act. The 3-judge district court in this case said that was their primary objective, to comply with the voting. But some of them thought, in addition, that they were helping the Democrats.
Right.
But it wasn't their primary reason. And so that's the issue before the court. One, can you do that at all? The main argument they're making is that you can't deviate from one person, one vote in order to comply with the Voting Rights Act. And that seems to me clearly wrong. The Voting Rights Act is the law of the land. You have to comply with it.
So we're talking deviating from population. Equality.
In order to preserve minority voting districts.
But when we talk about a population, what are we talking about?
Well, that's a different case. That's before the Supreme Court, another voting case, not involving Arizona. But the Supreme Court has held that voting districts for legislatures, state and Congress, have to be of equal population. They have never defined what they mean by population. Is it breathing people, or is it registered voters? That's the main thing. And they've left it up to the states to decide that. Texas has been using regular population. It's being challenged by people who say that they're living in districts that are underrepresented because their district has a lot more voting people in it than other districts. So that's another issue about the reapportionment that the court's going to be deciding this year.
As far as the Arizona case, what do you think the court's going to decide?
That's interesting, because the court took this case. They didn't have to. And so whenever they do that, you think there's a good chance that they might reverse. But what they would say, I can't believe that they'll say you can't make deviations in order to comply with the Voting Rights Act. If deviations are permitted for other reasons, that you would think that would be a very good reason. The harder question is, if it's part of the reason why you drew the districts the way you did, to favor one party or another, the court might say you can't do that, which itself would be ironic, because the court has refused to say that political gerrymandering is unconstitutional. I mean, racial gerrymandering is unconstitutional, but they've never said political gerrymandering. Well, if you can gerrymander the districts in order to favor a political party, what's wrong with taking a few people out of one and putting in another?
I think gerrymandering is the epitome of politics, isn't it?
So if you can do that, why not make this? But that, to me, is the harder question, and I think it's the case is going to come out the way Justice Kennedy.
Well, what about this next case? I'm guessing he'll have a pretty strong hand here. As we have another affirmative action case involving an American university, this time University of Texas, Austin. Talk to us about it.
Right. This is the case which I think more than any other this term will show whether the last term was an aberration or whether Kennedy is really changing. Because when Kennedy first came on the court, he was absolutely set against race-conscious affirmative action. He's never voted in favor of it, but he said you could never do it. He seems to have been softening since then. This case was before the court a couple of years ago. It's the University of Texas affirmative action plan, which is an interesting plan because most of their minority admissions, they get through what they call the top 10% plan. If you finish in the top 10% of your high school class in Texas, you have a right to go to the Austin branch of the University of Texas. That's the flagship thing. And that gets a lot of minorities in. But the University of Texas said, we want to do more than that, because the reason we're getting so many minorities through the top 10% plan is because the high schools in Texas are racially segregated. That's why we're getting so many minorities, because there are schools that are 95% minorities. So we're getting a lot of minority students there. And they're saying that's not the only kind of diversity we want. We want diversity of minority people who aren't in the top 10% maybe, but they're really people we want to have in the university for various reasons. And so they have an additional affirmative action plan. The top 10% fills 80% of the class. The other 20 is filled with a plan which takes all kinds of factors into account, including race. And the question is whether they can do that. In the last case, the Supreme Court, in an opinion by Kennedy, said you can do it for diversity reasons. That's a compelling reason. But you have to narrowly tailor your plan to your diversity objective. And it's not clear to us that you did that. So they remanded the case for them to reconsider it and narrowly tailor it. And the lower court wrote an elaborate opinion saying, we think that Texas wants to get diversity that they're not getting just from the top 10% plan. And so we think it is narrowly tailored. And that case is back to the Supreme Court. They took it again, which again suggests that maybe they're going to reverse that.
And Justice Kagan now has to recuse herself on that, doesn't she?
She is recusing herself, right? So there's only 8 people. So, but that means that if Kennedy were to join with the liberals, it would be a 4-4 decision. And that would be affirmed by an equally divided court. And the lower court opinion would stand. And it's a pretty good lower court opinion. So that'll be a real test. If that's 4-4, Kennedy really seems to be changing in racial cases anyway. If he stays with the conservatives and it's 5-3 and they knock out this plan, they could. There are 2 people on the court, Scalia and Alito, I think, or maybe Scalia and Thomas, maybe all 3 of them, have said they think no race-conscious affirmative action is constitutional. The court could try to use this case to overrule the case in which they held you could have race-conscious affirmative action, the Grutter case involving the University of Michigan Law School. I don't think they have 5 votes to do that. I don't think Kennedy will do that. I don't think Roberts will do that. But there might be 3 votes to do that. So if they're not going to do that, are they going to strike this thing, send it back to the court to do it over again?
All over again, one more time.
I think there's a really good chance that Kennedy will say, look, you tried, and I think you're in good faith, and so let's let it be.
All right, we move on to a tribal court jurisdiction case over non-Indians on the reservation in terms of civil case, not criminal, civil cases, correct?
Yeah, that's right. Criminal cases, the Supreme Court decided in an opinion by Justice Rehnquist a long time ago that tribal courts did not have criminal jurisdiction over non-Indians. So if you commit a crime on an Indian reservation, no matter what, if you rape a woman on the Indian reservation or commit a murder a member of the tribe on the reservation, the tribe cannot prosecute you criminally. Only the state or the federal government can do that. But that rule has never been announced for civil cases. In civil cases, the Supreme Court has said that the tribes can exercise civil jurisdiction over non-Indians if they have a good enough reason, if the conduct that they're regulating affects the welfare of the reservation. This case involves a sexual assault on a teenager who was participating in kind of apprenticeship program in a supermarket. The manager of the supermarket assaulted him sexually, and the victim is a teenage member of the tribe, and the manager is not a member of the tribe. He doesn't live on the reservation, even though he works there. And so the question is whether the tribal court has jurisdiction over that, and the tribal court said it did. And the Supreme Court's going to decide whether they do or not. The court could say, and it would be a disaster for tribal courts, the court could say that tribal courts don't have civil jurisdiction over non-Indians in the same way they don't have criminal jurisdiction. That would be a very important decision.
If the court decides that, the impact on, or if the court doesn't decide, that goes the other way, the impact on dealings with American Indian tribes.
It's very important to American Indian tribes. A lot of tribes are using the money they get from gaming to really upgrade their governmental structures. And one of the things they're upgrading are their courts. And it's hard because you want tribal members to be judges on the courts, but some of these tribes have no members who went to law school. But that's beginning to happen. And tribes are beginning to make their courts look more and more like Anglo courts. And they want to do that for a lot of different reasons. One of it is if they do that, they think maybe the court will let them exercise jurisdiction over non-Indians.
Right.
But if they don't make their courts look like Anglo courts, then the court's not likely to say that. So this is a really important case for the development of Indian tribal courts.
We have an interstate commerce case. It's kind of interesting because it regards drug crime. I don't quite understand how they're putting this, the drug crime affecting interstate commerce or not. What's happening here?
There's a thing called the Hobbs Act, which was passed under Congress's power to regulate interstate commerce. And it says that if you steal something, and if that theft affects interstate commerce, that's a federal crime, okay? You want to know what the facts of this case are? These guys, I forget where it was, they decided that they were going to rob houses of people who were marijuana dealers, because they must have a lot of cash around. So they went into two people's houses who were dealing marijuana, and they said, "Where's the marijuana?" And they said, "We don't have any." "Where's the money?" "We don't have any." So in one place, they took some watches and rings. They didn't take one marijuana cigarette from the two places, and not a lot of money, very little money, okay? The federal government is prosecuting them under the Hobbs Act because they have, it says, committed a theft that affects interstate commerce.
How?
Well, the theory of the lower court was that, hey, marijuana sales affect interstate commerce. The federal government has used the commerce power to ban possession of marijuana. So if the marijuana traffic is interstate commerce, then if you're going to steal something from somebody who's selling marijuana, that has to affect interstate commerce. What do you think of that logic?
Well, we don't have time for what
There's
I think.
something wrong there,
Yeah.
right?
So, the question to me, though, seems as though you have conservatives on the court who probably aren't all that crazy about, commerce power and limits
Right.
to commerce, yet they're probably not all that crazy about drug crimes.
Good point.
How are they going to vote?
Well, they're really torn in a case like this. If the past is any indicator, they care more about limiting Congress's commerce power. The conservatives care more about that than they do about catching a couple of crooks. And so this is a really important case. If the court were to do in this case what it did in the Lopez case about 15 years ago and say that, no, you can't do that, you have to show that the theft really affects commerce, that would destroy the practical use of a lot of federal regulatory statutes, because most of these statutes are not written to make you, if the statute that says that hotels cannot discriminate on the grounds of race, they use the commerce power for that. But you don't have to show that the discrimination that you're complaining about was from somebody out of state. Because hotels generally serve people from out of state. Well, if they do the same thing here, then this will be okay. But if they say here, no, you got to show that this theft really affected interstate commerce, that would have a negative effect on a lot of other federal regulatory statutes on the commerce clause. And I think there are 4 people on the court who would like to have that effect because they would like to cut that down. So this is a potentially very important case.
Interesting. We have a couple of death penalty cases. I'd like to go through them relatively quick because they both deal with the death penalty, but from very different angles.
Well, the main thing about the death penalty that people are interested in is that last term in a death penalty case, at the end of the term, the only case at the end of the term that Kennedy agreed with the conservatives, Justice Breyer wrote an opinion joined by Justice Ginsburg, which said it's time to reassess whether the death penalty is consistent with the Constitution, whether it's cruel and unusual punishment. Only 2 votes for that, but that's the first time that that's happened in that way. So people are thinking, hey, is the court going to do something about the death penalty? I don't think they are. But when they keep getting these cases, at some stage, I think enough justices will want to reconsider it that they will. These cases involve, one is a capital case where the defendant was black and the prosecutor struck every black juror, so it would be an all-white jury. That is illegal if you do it for racial reasons, but it's okay if you have other. I'm not striking you because you're black. I'm striking you because you're a woman. I'm not striking you because you're black. I'm striking you because you don't have a high school diploma. If you can explain the strikes on non-racial grounds, it's okay. If you can't, then it's unconstitutional. And here the lower court said that they had explained it. They didn't explain it. It's a very bad record for that. It looks clear that they used race. So the court has taken it, unusually, because the court usually doesn't decide factual issues, but that's what they have to decide in this case. The other case involves a case from Arizona some years ago held that factual issues that determine whether somebody gets the death penalty have to be resolved by juries. Judges can't do that.
The
right of jury. The ring case, right? That's the right of jury trial. Florida apparently has decided that they let the jury give an advisory opinion about whether it should be the death penalty, but they're going to leave it up to the judge ultimately. And the question is whether that kind of advisory role for the jury is enough. It strikes me that that's pretty clear that the court will say no.
Yeah, I was going to say that doesn't seem to make much sense. I mean,
I don't think so.
if the jury is supposed to decide, the jury is
think the jury's supposed to decide.
It's supposed to decide. Yeah.
It's ironic because a lot of people think in a lot of places that the defendants are better off if the judge is the one to decide, because the judge is more likely to be merciful than juries in many places. So you might be torn in this kind of case as well.
This next one, again, is one that I read these cases, I don't understand how this even got to this level. A Pennsylvania Chief Justice is ruling on a capital case that he prosecuted when he was a prosecutor.
He wasn't really in court prosecuting. He was the supervising prosecutor.
He ran his election campaign using this example as an I'm a tough on crime kind of guy, and he still wants to sit and rule on this case?
You have a problem with that?
What am I missing?
Well, I don't know. You're missing, you're not missing anything. He should not have done that. The problem maybe is that it was a unanimous decision. So his vote didn't make a difference. And they're making the argument that, hey, maybe he shouldn't have sat, but his vote didn't make a difference, and so you should affirm the conviction anyway. And it puts the court in a difficult position. I hope the court says, hey, you can't do that. You can't. I mean, why is Kagan recusing herself in the affirmative action case? Because she was Solicitor General when that case was in the office. She might have had nothing to do with it. So everybody understands that if you're the supervising prosecutor, you got to not judge that case when it comes to you if you're a judge later on. But what are they going to do if they say he shouldn't have sat on it? His vote didn't mean anything. I mean, his vote was not determinative. That doesn't strike me as being determinative, because even though his vote might not, he's sitting there with his colleagues, and they're going to be reluctant to say, hey, you colleague, you shouldn't have done that, and you did the wrong thing. The things you did as prosecutor are unconstitutional. So you could say, well, his being there, even though his vote wasn't determinative, he was kind of poisoned the whole atmosphere. But what do? They send it back to the same group of judges? They're not going to change their mind about whether he did something wrong.
But they're not going to change their mind, but at least Mr. Wonderful's not going to be sitting there passing judgment.
That's right. Well, he's retired from the court, so he wouldn't be there. But I hope that they make a strong statement that that kind of thing just won't work.
Okay, we had a double jeopardy case regarding Puerto Rico. Real quickly, this is because Puerto Rico is what? State, federal, what are they?
People don't understand that the double jeopardy clause just protects you against being tried twice by the same sovereign. So the federal government can try you, and then the state can try you. In this case, the federal government tried them, and Puerto Rico wanted to do it again. And the question is Puerto Rico a separate sovereign, like a state, for double jeopardy purpose, or is it like the federal government because the federal government has supervisory authority over them? And the Puerto Rico Supreme Court said, we're not a state. We're part of the federal government, and therefore we can't prosecute them. And the prosecutors in Puerto Rico have taken the case to the Supreme Court. There's a split in the circuits on that issue.
Yeah, interesting stuff. Okay, with a minute or so left here, will this be a blockbuster session similar to last time?
You know, you never can tell, because it all depends on the opinions they write. But it doesn't look like it will be, because last term, with the Obamacare case and the gay marriage case, it's hard to equal that. But if they were to do some radical thing with the Commerce Clause, for example, if they were to say that race-conscious affirmative action is unconstitutional always, those could be blockbusters. I don't think that's going to happen.
And you do think that Kennedy will eventually prove? Could he just bounce around? Could he just be a guy that bounces around from one side to the other?
Yeah, he sort of has, but he's always bounced in one direction more than the other. Last term, he bounced in the other direction. My view is that it's a real change. I think he's changing. I think he has been energized by the leadership he's had in the gay marriage or the gay rights thing. He's been the leader of gay rights on the court. And I think that has gotten them to think more about the strength of constitutional rights and about wanting to protect people's rights.
And any retirements?
I don't think there were going to be any voluntary retirements.
Okay, because you always want to watch out for that.
Yeah,
'cause
some
you-
of those people are pretty old, so
Yeah,
you never
yeah,
can
you
tell.
never know. All right. Well, we'll look forward to learning more about what happens during this session. Always a pleasure. Great to have you here.
Same
Thanks
here,
for joining.
Ted. Nice to be here.
Thursday on Arizona Horizon, Superintendent of Public Instruction Diane Douglas joins us in studio to discuss a variety of issues facing her office. And we'll look at a new study on concussions and the high rate of brain disease in NFL players. It's at 5:30 and 10 on the next Arizona Horizon. A reminder, once again, if you want to watch tonight's episode again, please do at azpbs.org/horizon. You'll also find previous episodes, and you'll also learn what we have in store for the future. azpbs.org/horizon. That is it for now. I'm Ted Simons. Thank you so much for joining us. You have a great evening.
Arizona Horizon is made possible by contributions from the Friends of Eight, members of your Arizona PBS station. Thank you.